We are very pleased to have two fantastic presenters, Douglas Dewar, or Doug Dewar if you want, and Pamela Palmer, both attorneys from Ellerbe Thompson. And I'm going to let them take it away. Take it away, Pamela.
All right, well, welcome everyone to this presentation. We are so excited to have the opportunity to talk with you about some very, I think, interesting and exciting employment law topics. As he stated, my name is Pam Palmer. I am an associate at Ellerbe Thompson. I've been with Ellerbe for about 2 years. I work with Doug, who's a great pleasure to work with. Prior to that, I did work as a trial attorney at the Equal Employment Opportunity Commission in Atlanta. And prior to that, I did some employment law work representing plaintiffs. And so I had a little bit of experience on all sides now, and I represent private employers and public employers with Ellerbe. So the first topic that we are going to dive into now, Doug, did you want to go ahead and introduce yourself too?
No, I'll take care of that when we get to my section. Go ahead.
Okay,
yep.
Great. So let's begin with part 1 of the presentation today, regulating employee social media activity. Now, I don't know how many of you all use social media, but I would imagine that there are several people who do. I do myself, and there are all sorts of rules and different things that surround social media. Today, though, we are going to focus on 3 topics. First Amendment issues in social media. What is protected? When can the government act to protect its interests? The second part will be off-duty use of social media and workplace policies. So what happens when an employee uses their own personal social media off-duty? What sort of implications or liability is there? And then privacy rights, specifically with hiring decisions and monitoring. What can you look at for a job applicant or candidate social media? Are there any legal implications there? And also monitoring an employee's social media while they are employed with you. So those are the 3 topics that we're going to jump into today. Now, generally, people think, oh, the First Amendment is the right, you have the right to free speech, the right to say what you want. Everybody, thinks that that is your First Amendment right. That's true to an extent, but of course, over time, the law, statutes have sort of chipped away and narrowed that First Amendment right. So, generally, you can't make certain threats, use fighting words. Certain types of speech are excluded from this sort of free speech category, things like, perjury and defamation. And so when we're looking at First Amendment issues concerning social media, generally, public employees retain their identity as a citizen and don't surrender all of their rights under the free speech clause. So if they're speaking as a public citizen, then they still maintain those free speech rights. Local governments also retain their identity as employers and have a legitimate interest in promoting the efficiency of public services that it provides through its employees. And so there's this balancing test. What is the employee saying, and in what capacity are they speaking? Are they speaking as an employee or representative of the organization, or are they speaking as a citizen? And then the government has to look at what is going to be the interest in ensuring that they're promoting the efficiency of public services. So we have this balancing test here. This balancing test was also promulgated in the Pickering versus Board of Education case, where a teacher wrote a letter that concerned the cost of education within the board. And so her rights in that case were considered protected because she was vocalizing her concern as a public citizen, and it was a matter of public concern. So we also get to this test under the First Amendment law concerning public forum analysis. So a designated public forum involves a situation in which a public agency intentionally opens a non-public forum for public disclosure. Now, a non-public forum is a place that is not by tradition or designation a forum for members of the public to communicate with each other. And then you have 3, a designated public forum. And so when we're looking at social media, we kind of have to look at it almost as if it is a sort of public forum. Many people have public profiles. They say once you post something to social media, it is there for an eternity. And so when you're looking at whether the speech is protected, you have to look at this public forum analysis. Public agency meetings are considered limited public forums, as courts have upheld, rules of decorum necessary to prevent a speaker from disrupting a meeting. And so, when you're having, open meetings or those types of conversations and meetings within a venue, then that would be considered public as well. So some questions to consider when you're evaluating whether the speech is protected are, does the local government's employer's interest in the effective and efficient fulfillment of its responsibilities to the public outweigh the employee's interest in engaging in the speech in question? And so that could be something, for example, where the organization has a particular mission in providing services, and the employee makes a statement that is in disagreement or against those services. If it is something to where the public service outweighs that employee interest, then that speech would not be protected. Did the employee's overall conduct include non-speech not on a matter of public concerns? For example, if someone makes a comment about their manager and they say, I don't like her, she's, a mean person and unqualified for her job or something, and they post that, would that be a matter of public concern? Did the conduct disrupt or threaten to disrupt important working relationships? Did the conduct interfere or threaten to interfere with internal operations? And so when we're looking at all of these questions, it's never just a completely, black and white, clear-cut issue. There are a lot of gray areas. And so when we're assessing whether the First Amendment protections apply here, we have to look at all of these questions. Did the conduct undermine or threaten to undermine leadership's authority? Is the employer a paramilitary organization? Because sometimes a heightened need for order within that type of organization may cause for a different level of evaluating the interest there. So when an employee is making a comment on social media, whether they're using Facebook or they are making a comment on Instagram or posting a meme, even reposting something on Twitter, there is a potential liability for employers depending on what the context of the speech is and the employees, whether they're speaking as a citizen or not. And so we have to look at our state whistleblower protection laws. Fraud, waste, and abuse, including public funds, is a form of whistleblowing activity. So if an employee raises an issue or concern of fraud, waste, and abuse within the organization, they may have protections there under Georgia law. violation or non-compliance with a law, rule, or regulation, if they are speaking about a particular issue where the organization or the representatives of that organization have violated a rule, that may be protected. Then we have retaliation under Title VII, which is Title VII of the Civil Rights Act, which prohibits race discrimination, religion discrimination, national origin, sex discrimination, the Age Discrimination in Employment Act, ADEA, and then we also have the ADA, which is the Americans with Disabilities Act of 1990, amended in 2008. And so if there is particular speech that concerns them making a report of discrimination under any of those statutes, whether they're participating in an investigation that's being conducted, whether it's an investigation internally or perhaps an investigation with a federal agency, or whether they're in opposition to a particular comment or conduct by a supervisor or another employee, that speech is protected as well. There's also this Fourth Circuit case, which kind of gives us an example of what type of speech is protected. It's the Liverman versus City of Pittsburgh Fourth Circuit case from 2016, where the Fourth Circuit reviewed the discipline of 2 police officers from the City of Petersburg Police Department, and they overturned their discipline because they concluded that the department's policy was overbroad. And so there are also some general rules concerning off-duty use of social media. And so one important thing to remember is that one employer cannot prohibit social media activities on the personal computers, phones, devices of their employees. Okay. Now, of course, you can have cell phone use policies and things of that nature so that they don't disrupt the workplace, but you can't explicitly prohibit any social media activities. And you must consider, one, those First Amendment restrictions again, the whistleblower protections, and how you're applying the policies. Consistency. Consistency is key when you are dealing with any sort of employment law issue or potential liability in any area of the law. You want to make sure that you're carrying out the policies consistently, because even if there is, no discriminatory intent, there was no intent to deprive someone of their rights. If you say, well, here's one person that is allowed to, use the cell phone policy in this way, but this person, we're not going to apply that same rule to for whatever reason, or we forgot, to, give them a written warning for this, but we allowed a written warning to go out for another person, that then creates issues. So really consistency is key. And then again, is the employee acting as a citizen, or are they speaking in the course of his or her or their job duties? So other general rules, there's another Fourth Circuit case in 2017, Grutzmacher v. Howard County, where a battalion chief of Maryland's Howard County Fire Department sued the department for retaliatory firing based on his Facebook posts and likes. Now, in that case, the decision was upheld to terminate that particular employee. In that situation, the employee had posted a statement on Facebook referencing news coverage of a gun control debate and alluded to killing a, quote, liberal with another liberal. And the employee subsequently liked another post, but it had some racially suggestive language in that post. And so in that situation, that termination was upheld. But a few things to take away from that case were a like on Facebook or a like on Twitter could be considered speech. You know, it's not just making comments and using words. It could be as simple as liking. I know LinkedIn has multiple levels of options you can select when you see a post. You can love it, you can like it, you can celebrate it or use a hand clap, you can dislike it. And so all of those particular functions could be considered speech. And so that's one thing you want to be mindful of when using social media and also regulating employee social media. Speech on matters of personal interest are not constitutionally protected. Personal grievances and complaints about conditions of employment do not constitute speech about matters of public concerns. Again, those sort of just specific complaints about not liking something, or, you know, it has to be not just, you know, a personal, a gripe that the employee has. And then you have to look at the effect of the speech on the government entity's mission, function, and personnel. So all of those factors are sort of general rules you should look at when you're assessing social media speech in the government area. So lastly, we're going to talk about these privacy rights hiring decisions. According to a 2018 social media recruitment survey, 70% of employers and recruiters say they use social networking sites to research job candidates. That's pretty much, you know, everybody. That's a majority. I know I find myself Googling people, you know, who I may not have met, who I may have an upcoming meeting with, you know, just to see their profile, see who they were, see if we share some interest or education in common. And I think that's a pretty common thing for people to do. However, if you are an HR person or you are making hiring decisions on behalf of the organization, you have to proceed with caution here, because, you know, even though you say, oh, well, I just Googled their name, it's Google, it's public information, you know, it's out there so I can look at it. You have to be careful, because from that Google search, you will probably learn protected traits of that particular person that you may not have known before. For example, if you Google a person's name and their picture pops up, you may be able to see their race, you may be able to see their age, their particular religion, maybe they're, you know, posting themselves going to church, or maybe a particular person's disability. You may be able to find that information through some sort of public search. And so if you're learning about that, that could open the door for potentially someone, you know, complaining that a protected trait was used in a decision not to select them or not to hire them for the job. So you just have to be aware of that. You just have to be aware of it. And also be mindful of open records and record retention requirements when conducting background research on a candidate, because social media, they count as records, whether it's, you know, electronic like an email, or if it's a direct message to a particular employee, that those records are considered documents. So you can use social media in a great way to help you in hiring decisions. You know, as long as there's a common practice and policy that's implemented consistently, that is the key. So one, create a list of social media sites that will be searched for each applicant. You know, we're gonna just search the Facebooks, or we're gonna just search the Instagram and the Twitter. And create a list of lawful information about applicants desired from every search. What are you looking for when you're doing this search? And then screen all the applicants using that lawful criteria. And then lastly, don't friend or follow applicants to gain access to non-public social networking profiles. That's really important there, because if they have a private setting on their particular profile, and then you go in and follow or friend so that you can get access, that is taking it sort of a step further when it was clear that the employee's intention was to have that sort of information private. Now, of course, if they volunteer that information, you can do that, but it's best to proceed with a consistent practice that acknowledges that privacy setting of the employee. And then, oh no. So so we talked about the ways that you cannot prohibit personal social media use, but you can prohibit social media activities on city and county phones, obviously, on those sort of devices that are owned and issued by the government. And you can prohibit that during work hours. As I stated, you can have a policy because you don't want, constant cell phone interruptions, notifications, going off at all times. Maybe keep it on silent, maybe don't have it in certain areas. But you can definitely regulate social media when it is during the work hours on city devices. And then if an employee identifies as a city or county employee, then their social media is going to be more closely scrutinized than a person who has not listed their particular job title and position and employer on their page. If they do that, they may be treated as if that statement or speech that they're making is on the job. And they will be evaluated for compliance with other city and county policies because they're clearly acting as an employee and representative of the local government. And then if there's improper use, such as workplace harassment, conduct that is unbecoming, conduct that damages public confidence, then yes, that social media activity will be under more of a magnifying glass than it would otherwise be if they were just speaking as a citizen. So notify employees. Simple, communicate. Tell them you can only speak in your personal capacity. I've seen disclaimers on some Twitter profiles where it says, these comments are not endorsed by a local government and these are my own statements. I've seen those sort of disclaimers. I don't think that necessarily absolves the person from any sort of punishments or things like that or discipline, but people do make those disclaimers. And then employee bears the consequences alone. City and county reserves the right to pursue indemnification or a contribution claim against an employee if sued. And then let them know that you reserve the right to monitor social activities. If you have a policy, you can just get a signed acknowledgement that the employee understands the policy and understands the expectations. Disclaim privacy, and then monitor use uniformly and consistently with the policies. And so before we go over to part 2, just some do's and don'ts. Do adopt and publicize a social media policy. Do define what sort of content falls outside of the mission and the purpose in the organization. You can even list out these types of activities or comments are not a part of our purpose. Do advise staff that they may not delete postings simply because they are critical. So if you have a staff person who manages the local government social media page, if someone comments something that is that you deem rude or that you deem that you disagree with, don't just immediately delete it. You may be able to delete it later, but just because the comment is not in line with the mission, you shouldn't automatically remove it. And then don't require or force or demand employees to provide their personal login information for personal accounts. And don't take adverse action against employees who are engaging in protected activity via social media sites. And that, again, is activity that is concerning a matter of public concern. And then if a governing body member don't engage in discussions on issues within an agency's subject matter jurisdiction on fellow decision makers' social media outlets. So be careful of those back and forth comments, those conversations that you have, so that you ensure that you are not wading into any potential legal traps or legal territory there. And so, you know, overall, the sum of regulating social media activity is really to assess the speech and think about those questions and considerations about what is protected in the instance. And then look at, you know, potentially, you know, sort of what sort of ramifications can come from, you know, infringing or disciplining an employee who makes certain speech. And then look at your policies. Look at your policies, see if they're consistent. They may be written, but are they being implemented and applied consistently? That's the most important part. Even if you have something written, you want to be sure that it's being implemented consistently. And so that concludes my portion of the regulating social media activity. And I will hand it over to my colleague, Doug Dewar, to continue with part 2.
Great, thank you, Pamela. I appreciate that, and hopefully Dan will be able to get us over to presenting a little bit differently, so I can move the slides. No challenge there, Dan.
Hold on one moment. I'm going to help you out here. Let's see.
While Dan is doing that, I want to say give my comments and welcome to the people on here who are viewing this particular presentation. Appreciate you all coming and attending. I will go ahead for some. I can't tell who signed up and who's on here, but I did want to point out to those of you who have seen me speak before. Pamela herself, who's been with the firm for a while, has never seen me without a tie or a bow tie on. But I'm speaking to you from my beach vacation. So I'm sorry, I just couldn't bring myself.
I'm very jealous.
I couldn't bring myself to pack a tie and bring it along with me. So an event, welcome. To add my little background for those of you who don't know me, I have been working with the law firm of Ellery Thompson for over 30 years now. I was obviously 12 at the time that I started practicing law, but I joined the firm after working at the Georgia Supreme Court for a year for 2 of the Georgia Supreme Court justices following law school. I've been working with the local government for pretty much most of that time, probably 30 out of the 31 plus years that I've been working with that. And so I look forward to us talking with you today. And I'm going to talk about, and obviously we had Pamela address the social media, because when I was in law school, we were still using rock tablets to communicate, and there was no such thing as social media. In any event, moving on to this, we're going to talk a little bit about coping with political divisiveness and hypersensitivity in the workplace. I know that if you follow it, there's been a great lament as of late about the increase or apparent increase in partisanship that we are experiencing over the last few years. But I would actually point out that the issue of partisanship goes that the ink wasn't even hardly dry on the Constitution when partisanship really began, and it goes all the way back to even the election of Thomas Jefferson when he was running against John Adams. Jefferson published in the papers a description of John Adams that he was essentially blind, bald, crippled, toothless man with a hideous hermaphroditic character, with neither the force and fitness of a man nor the gentleness and sensibility of a woman. So this is pretty harsh criticism back at that time period, and was at least demonstrably false, because Adams was neither blind, disabled, nor toothless. So political partisanship goes way back, and you can even find more recent instances of extreme partisanship. If you look historically, there was a notion that perhaps a bipartisanship persisted during the 50s and 60s and going into the 70s and maybe 80s, and we hear these stories about it. But you don't have to look far back into the civil rights movement and going all the way back into the early 1900s with the degree of partisanship that we had at that time and forward to this day. So it's certainly nothing new, although perhaps there's a greater sensitivity to the issues of partisanship. But what I want to talk about here today is sort of three aspects of it. Since this is from LGRMS and we're on HR topics, we're going to talk about impact on the workplace, some of the issues, legal issues that come into play there, and the ways it can crop up at work, and the ways that we might want to be able to focus on resolving and addressing those things. So as I mentioned here, it's certainly not something new, but how does it impact us at work? Well, it impacts both you and the local government sector, as well as your colleagues who are working in the private sector, right? Obviously, employee morale is greatly impacted by the issue of political divisiveness at work, with people being concerned about what they can and can't say, stating their own opinions about political issues that face our nation, or the state, the county, or the city itself in there. And I would say that some people might be hesitant or reticent about speaking about their thoughts on that, and that's certainly going to be others who don't hold back and don't see much in the way of a filter. And the way that can come between working relationships is obviously a concern, because that affects the city and its ability to perform. It can, to the extent that those political controversies play themselves out into a larger audience outside of the workplace, it obviously impacts the citizens of the city or the county that you're in, right? The working relationship between the government and the citizens, the way that's perceived, the other relationships within the workplace and outside that with your elected officials and other stakeholders within the city or county. And it can this is more so in the private sector than in the government sector, but just for the purpose of being complete here, obviously it can go to the issues of financial health of an organization, and I'll just pick on issues such as Delta Airlines or Chick-fil-A or Hobby Lobby or some of these other, name businesses that that have Coca-Cola, who have walked into the issues of the political divisiveness and trying, on one hand, to address larger social issues, while also trying to be mindful of the impact it has on their own workforce and how to deal with that, and a desire for by workers and employees that their employers speak up to address those certain issues of the day. So here's just sort of a recent survey by the firm Gartner, which you may or may not have heard of before. A lot of people are more familiar with Gallup. But Gartner, it also does polling and does advising of a variety of different type of industries. And they did a survey following the 2020 election. And in that, probably perhaps not surprising for anybody who is in a workplace, 78% of employees reported that they do talk about politics at work. And obviously, during election times, that's more of an issue, more likely to occur than during off years. But there in cities, municipalities, local government, you certainly have elections more frequently than every 4 years, more likely not. So there'll be more conversations in those instances. 47% of respondents claimed that the presidential election that we just went through impacted their ability to get work done. And that can be for a variety of reasons. And as I point out in the prior slide with the impact on morale, it's distracting, right? And if you know that if you're having a conflict with a coworker that you need to work with over issues of politics, and that gets in the way of getting the job done, and that's a problem. And you can see that 47% said it impacted their relationship, their ability to work, but 36% say that they wouldn't talk to somebody because, or at least avoided that because of their political leanings in those conversations and that again, if you study any history on this kind of topic, you'll see that is not something that's new. There's people will, if they have political differences, avoid trying to speak with those that they have politics with. So it definitely interferes with the efficiencies of trying to provide the service that you have to provide. And then 31% report that those conversations are in fact stressful. So not too surprisingly, when we look at the top 5 conversations that occurred in the workplace in 2020, according to the same sort of study, obviously number 1 was the presidential election itself. No surprise there, even though the primaries results were resolved fairly early on in the season. Things picked up into a very hard-fought election. And certainly once the election was completed in early November, or at least the active voting aspects of it, the controversy that came off of that, that obviously was a bit in there. The issues of COVID-19 and the pandemic, and whether that was politicized by one or both sides to the extent that you looking at a two-party system, where it was in fact a political issue for conversation as well, and certainly became a matter of discussion. Race issues, right? The Black Lives Matter issues and issues of racial justice reasserted themselves during 2020 and became much of a topic and issue there with marches and other events in there. And then also at the same time, we had more developments on the LGBTQIA plus issues, sometimes referred to as the alphabet issues in there, and that with some decisions out of the United States Supreme Court. And then issues of gun rights, which also has been ongoing for a fair number of years and still creates controversy there. Frequently, we see that more as an urban or outside non-urban dispute, but it still impacts itself in a variety of different ways. So all of these types of issues that we come up here, and I've just sort of highlighted the top 5. So what are sort of the legal and constitutional issues comes on in there? So I'm going to take this in sort of a little bit reverse order from what Pamela spoke about, although there is actually quite a bit of overlap between the issues of social media and political discussion and discourse within the workplace, because a lot of this discourse happens not just with some verbal communication or maybe perhaps altercation in the workplace itself, but also what happens on social media. A lot of individuals are connected with each other through social media and see each other's posts and what people have to say, and that's an issue there to be aware of. As a reminder, I'm just going to step aside here for say, if you're a supervisor, you really should not be connected with your subordinates by social media. I'll just say that. I know that might fall on some deaf ears, but in any event, back to the discrimination and harassment issues here when it comes to issues of politics, right? We have some of the same issues here that Pamela was alluding to on social media with the Civil Rights Act of 1964, Title VII, and for race, sex, and religion, all that sort of. All these laws prohibit discrimination and harassment based on a protected characteristic, but as the slide notes here in the second bullet points, they don't prohibit political views or prohibit discrimination or harassment based on political views. So therefore, these laws don't prevent that type of having diverse views, or actually on the part of employers in the state of Georgia, at least, doesn't prohibit any kind of discrimination on the basis of that. So for your colleagues in the private sector, if there's an opposing political view, none of these laws would prohibit them taking an adverse action based on that aspect of it, based on itself. But as the slide notes on here, sometimes issues of a political opinion can have either racial or sexual overtones as it relates to issues of sex. Because remember, and you see that here from the prior slides, right, when we're talking about issues of racial justice, the alphabet issues, LGBTQ+, that those things can come into play and still have aspects of it that touch on protected characteristics, race, sex, religion, national origin. And so although the laws themselves don't prohibit discrimination or harassment based on those things, in fact, it can, in some instances, limit or provide some protection against adverse employment actions based on that topic. Now, because we're talking here to city and county governments, right? That's why we're here, LGOMS. We have the same sort of First Amendment considerations that come into play that we were just talking about, that Pamela was just talking about previously as it relates to the use of social media. I'm not going to reiterate all of that here, right? Pamela's covered that very well. And when you get the PowerPoint presentation, you can go back and see the slides that really cover very well sort of the questions and the balancing that comes into play in there. But you still have a First Amendment right to address issues of public concern, whether it be a social post, whether it be writing to the newspaper, what those things come into play. As Pamela noted, we're looking at whether you're using a public forum, whether it's a non-public forum, right? So we may be able to put some limits on the engaging in some speech, even if it's a matter of public concern within the workplace, if it's disruptive and causing those types of things. And we're looking at the impact of that speech on the workplace itself. We're looking at the speech to determine if it's a matter of public concern. We're looking at whether the person is speaking as a member of the general public or as a member or as an employee of the issue of the city or county itself. In other words, if that speech is part of their job and responsibility, because if it's part of their job to speak on a particular matter, then that is under current law not necessarily protected First Amendment speech, even if it's arguably a matter of public concern. And so this is something to be aware of. Now, as I mentioned here, there are some areas that, like everything, can be a little difficult sometimes to know, right? Because there's these topics, and we have listened up here about on this particular slide some areas that you might consider to be gray areas of topics. So, are they political speech? Is it not political speech? Is it a matter of public concern? Where does it come into be where the issue may appear to be somewhat neutral, but is not? So, for example, particularly in the issues of racial justice, we're looking at law enforcement funding, police funding of that. On that, are we talking about racial justice issues? Are we talking about political public concerns? Is even that commentary itself a political statement? And these are areas where you can have particular areas of concerns in here as it comes through. And it's covered up on your slides, right? Law enforcement, sports, who knew, right? Could become political. There used to be a time when we would say, hey, avoid issues of harassment, talk about sports. Well, that's still true, but it can still come into play in which the sports organizations have responded to issues that are political. Again, a pandemic response, masking, not masking, vaccinations. And there's also then issues of nuance, the issues here that can come into play that may in fact be political in a way and need to be something that you need to be paying attention to, because they can have in fact a impact on the workplace. So here are some issues that that can come in that you want to be aware of. So here is this is a little bit of a distinction. It shows a distinction between kind of maybe what you're seeing in some of the materials available to you that relate that are very broad brush and deal with both public and non-public employers. And sometimes your colleagues in the private sector have it easier. They always think that you have it easier, but we all know better, right? So here's a simple situation to come into play, and that is what do you do if an employee comes in wearing a Black Lives Matter hat? Is this a political statement, and are they protected under the First Amendment? As Pamela was mentioning earlier before, the First Amendment, right? It governs well, public sector and not so much those in the private sector here, particularly in Georgia. And here, this court in Massachusetts said that, in fact, the company could take disciplinary action against somebody for wearing a Black Lives Matter paraphernalia because it violated the company's dress code, and that's not prohibited by any free speech rights. But when you come down to the public sector, so here the court decision involved a public entity, a port authority, said that in fact it violated the First Amendment rights of the employees by prohibiting them from wearing a statement that says that Black Lives Matter, because that was addressing an issue of racial justice, which is a matter of public concern. Now, is that right unlimited in the public sector? And the answer to that is no, it is not. There are, in fact, you can, in fact, prohibit paraphernalia that might address issues of public concern. But again, it's going to be a severe balancing test to determine whether it interferes with the public service that's being provided. So, for example, your law enforcement, where it be your sheriff's deputy or your police officer, might wear a pen that says Black Lives Matter, but again, because of the nature of their work and the need for uniformity, the sheriff's department or the police department, if they don't, assuming that they have a neutral policy on the issue of other types of paraphernalia besides that which is specifically authorized, could in fact prohibit that. Back to what Pamela mentioned earlier about use of social media for either disciplinary or evaluation process, you want to look at being consistent and the consistency in that aspect of it. Here we're looking at what about if a manager, a leader posts a meme to his personal account criticizing the police department? I don't even know what a meme is. No, I'm just kidding. If they post that, can that in fact be a situation here where that is permissible? And here the manager is not, or the leader is not in the police department, but in another district department. Is that individual prohibited from criticizing the police department? And the answer to that in this particular case was no. That in fact this could be permitted. It was, while critical, it was polite in this particular instance, and they were speaking as a citizen, not as an employee of the city, and they were not as also being not a member of the police department, did not disrupt good order within the police department. What about refusing to take a mandatory COVID test or follow a vaccination policy because they believe that COVID is a hoax? Here, the EEOC, the Equal Employment Opportunity Commission, has issued guidance that makes clear that an employer can require employees to obtain a vaccination as a condition of work. Obviously, you need to be mindful of making exceptions based on religion or the like, and those types of things. I'm not advocating one way or the other. There are other considerations that come into play as to whether you can require a mandatory vaccine or test for COVID. That's beyond the scope of this discussion. But the point of it here is that this, because it might have political undertones to it, doesn't mean that it's necessarily prohibited by the First Amendment or otherwise. So here, a couple of things to try to avoid having political interference at work. Right, have a conduct code about just in general about prohibiting bullying and the like. Make sure that your harassment policy covers things like sexual orientation, gender identity, all those types of aspects. Make sure it's broad enough to cover what's protected. You may want to consider ensuring having a time off policy for voting. That's already to some degree required by law. If it's by this Georgia law, if the employee's shift doesn't allow them either 2 hours before or after work to go vote. So you might want to consider that or even expand upon that a little bit. As Pamela mentioned, social media policy is a good idea. Keep that in mind. We're going to likely have complaints going forward. Again, there's increased sensitivity to the issue of political discourse in the workplace. So you're going to get complaints. What is your plan for that? How are you going to identify and what you're going to do on that? And you're probably going to want to make sure that you have training on these types of issues. Maybe even consider adding as part of your harassment training, because that's again, this is becoming an area of increased attention by both employees and otherwise. So with that, we are at time for questions. I had told Dan that we would reserve 10 minutes for questions. I lied, obviously, because we only have 7 minutes for questions in here. But please pose, let us know what your questions are. What is it that we need to go back and cover? And if you want to include comments about what a great job Pamela and I did in your question, feel free. Dan?
You did a fantastic job. Great job, both of you. Thank you so much. And again, I'm sure the comments will come flowing in. I hope we don't overcharge. See, great job. Anybody have any questions? Anything that you would like to ask? There is no question too personal for these two.
Well,
maybe. It was very helpful.
I may not respond to one that's too personal. That's right.
So anybody else have any questions? We got, thank you for the information. Information is great, very helpful and to the point. Lots of good praise here. Anybody with any questions?
Pamela, we were just that good.
I guess so.
I guess you were. It was an interesting topic.
On the table.
Topical based on things that are going on a daily basis, and something that what do you suggest? How do you suggest, ultimately you provided a good overview for leadership. What do you suggest? What kind of training do you suggest to your employees?
It suggests to employees or employers?
Yeah, to employees. What do you suggest that these folks provide to their employees?
Oh, what employers provide to employees in terms of training. Okay, I was going to say, I'm sorry, Dan, we only advise employers, not employees. Was that a trick question on your part, just to check to make sure that that's still the case?
No, that was it.
Yeah, sorry.
No, go ahead.
Okay. Well, it's actually, and this actually comes from the EEOC to some degree, and Pamela might be able to address it, although she was a trial attorney, and so thus by definition, controversial or confronting. I can't even say it. Confronting people versus doing the policy and stuff like that. But the EEOC itself issued some guidance that I think informs the type of training that we try to provide as part of the harassment and otherwise, and that is sort of a training on civility and that type of aspects of it. It's a sort of step beyond kind of what the basic harassment training provides, right? Because harassment, we're trying to sex, race, religion, national origin. This is where you cross the line and you violate and create legal liability or otherwise, and kind of what your job is as a supervisor and stuff like that. Civility training takes it sort of a step beyond that and addresses sort of the aspect of being sort of more sensitive, culturally sensitive to people's individualism. I wouldn't call it diversity training, although there are aspects of diversity training and civility training of it. But that type of sort of acknowledging that everybody is different and comes from a different background and sort of those things, and you need to be sort of sensitive to that and open to receiving views and opinions that are different than yours. Pamela, I didn't want to step on that for that, but maybe you have something you want to add on that. So that's how I would probably step up, take that harassment training to the next step. Pamela?
Yeah, I agree. I think a lot of, I mean, I've just seen on the private side, a lot of businesses instituting sort of civility policies and workplace civility trainings, because although it sounds basic, you know, to treat everyone with respect, I think because of the political climate that we were in and are in, people become very passionate about their beliefs, and they have very strong beliefs. But, you know, just because you believe one thing and another person believes another doesn't mean that you, you know, sabotage them at work, or you have to knock their head off because you disagree. People have disagreed, but there are ways to handle those disagreements. And so I agree with you, Doug. I think it's more than diversity. I think it's more about an awareness and an understanding, and then inclusion. How are we being inclusive of the fact that other people have views, and how are we then responding to that? And it should be something that is amicable. It should be professional. And if that's the case, you won't even have to really worry about the bullying that leads to harassment, that leads to, you know, calling Ellery Thompson. We got to need some help over here. It's blown up now. You know, if you take it back a few steps, I think that's a better way to manage it.
And isn't most of the root cause of these harassment claims and other claims related to just at least the perception of being disrespected, correct? Or not?
Yes, no, yeah, it is. Oftentimes, you know, it's become it's being repeated somewhat by President Biden, but in fact, when we give training on what we call labor relations, which is which is really sort of like union-free type training, it's about dignity and respect, and this is true. I actually include a good number of elements of that in my training on about HR issues and that sort of stuff. Is about treating individuals as individuals, treating them like essentially you yourself would want to be treated. You want to be treated as an individual contributor, and that didn't change just because you moved into a supervisory or leadership role. You wanted it even when you didn't have those additional responsibilities. So dignity and respect is the way to do it, and to try to train people on that. Obviously, we focus more on providing that to supervisors, being that they're in positions of authority and power over the others, you know, subordinate individuals, obviously, but that's a focus. So
the training that you talked about, is that something that people can obtain, that for contact you, the sensitivity training? Is that something you're willing to do for members for a fee, I would assume?
Dan, you know I don't make those kinds of decisions, but good effort on your part. I'll give you that. So that's something that we can work with you, Dan, on what might be available at some point in time. And by the way, you turned off the recording, right? Because I don't want the rest of the people in my office to hear this.
We'll edit all this stuff out. So very good. Well, I guess nobody has any questions. Thank you all for your participation. Thank you both, Douglas and Pamela, for your presentations. You did an excellent job on very important topics. I will say goodbye to everyone, and be safe out there.
Thank you. Have a good day.